dispute was in the nature of a pre-election, pre-nomination dispute. County Returning Officer, Mombasa County, and telling the County Returning Officer anything with respect to eligibility, then approaching the DRC and challenging or asking to be enjoined in that matter. So, my lady, as you may be aware, there were two different matters before the DRC. The fourth respondent, that was DRC complaint number 127 and complaint number 136. 136 dealt with the fourth respondent. It was the fourth respondent's complaint. Fourth respondent, yes. In none of these complaints did this specific party represented, or parties represented by Njiru, seek to join and be heard on the pre-nomination issues that they have with the petitioner hearing. They never attempted to even join as interested parties, and they never participated. Now, having said that, sorry? Okay, so having said that, then one clearly knows that this court does not have jurisdiction to hear this matter. This is a pre-nomination dispute, and unfortunately, some of the sad news that we have to deliver to Njiru and his clans is that they are time barred. DRC has its own timelines, and any council, and I know Njiru is a very diligent council, ought to peruse the law and pursue matters within the confines of the law. The law says you go to DRC within a specific timeline. That's exactly what you do. So this court does not have jurisdiction to entertain a claim such as this. And finally, perhaps I can also add that contrary to assertions being made here, there is absolutely no nexus between what was before Majanja's court and the rest of the members and what is before you. Nothing at all. No connection. So therefore, this is an abuse of the court process. It is meant to further delay this procedure. And further, perhaps I could donate 2 minutes to my colleague so that you can see there is 1 minute wonder. Okay, I'll give him the 1 minute, but the application fails to meet the threshold that has been stipulated by your own jurisprudence on what you need to be able to be granted the orders.
My ladies and my lords, with the kind permission, my name is Ochieng Oginga. Now, first I wish to submit that the application for joinder is not automatic, and it involves the exercise of this court's discretionary powers. Now, secondly, these proceedings are completely distinct from the petition that was heard by this bench, differently constituted. So yes, my dear. So that you're being invited to relook at that petition to supervise this same court as differently constituted and to render a different opinion. My lords and my ladies, I refer the court to the decision of Francis Karioko Muruatetu versus Republic, that is Supreme Court petition number 15 as consolidated with number 16 of 2015, where the court sets out the parameters and the role of an interested party. First, the Supreme Court such a party must demonstrate that they will be affected by the decision and thirdly, they must demonstrate the necessity for being joined to such proceedings. Now, in regard to public interest, my lady and my lord, now I submit public interest is not a blanket principle for joinder of parties to proceedings. Again, an individual's interest cannot override the general public interest. Again, more importantly, even the right to access the courts under Article 48 of the Constitution are regulated so that it is not automatic that a party can jump into proceedings and seek refuge under court to rules 5 and 6 of the rules of procedure on the settlement of disputes by the second respondent. That is rules 5 and 6. That is the rules of procedure on settlement of disputes by the IEBC Dispute Resolution Committee, which grants any person the locus to institute and lodge a complaint pertaining to a nomination again, I refer the court to Regulation 47 of the Elections General Regulations, which in fact grants any person again the locus to lodge a complaint. Sorry, my ladies, that is Regulation 43 of the Elections General Regulations, which grants any person again the locus to lodge a complaint with the returning officer at the time of nomination, so that the court should reject the submission that this dispute has crystallized as suggested by the applicants. Finally, my ladies and my lord, permit me to refer the court to the Francis Murwatetu decision, and that is specifically paragraph 42 of that decision. My lady, as I wind up, permit me to read this. It says, therefore, in every case, whether some parties are enjoined as interested parties or not, the issues to be determined by the court will always remain the issues as presented by the principal parties, or as framed by the court from the pleadings and submissions of the principal parties. This is important, my ladies and my lord. An interested party its own fresh issues or introduce new issues for determination by the court. One of the principles for admission of an interested party is that such a party must demonstrate that he or she has a stake in the matter before the court, that stake cannot take the form of an altogether a new issue to be introduced before the court. So that my final submissions, my lady and my lord, is that the interested party cannot come with its own new cause of action and purport to introduce it as one of the issues to be determined in this petition. My lady, this petition is an appeal against the decision by the IEBC committee, so that the parties are limited to determining the petition as friendly. Thank you, my lady.
Just 30 seconds, the permission. You allow me. Yes, ma'am. Just 30 seconds for the response. Yes, ma'am. Very political, I just report my name. Just 30 seconds. Thank you, Madam.
Yes, for 30 seconds.
I appreciate for the ordination. I have 3 issues, Madam, which I want to bring to the attention of this court. Issue number 1, it is very clear, even from the applicant, that they participated in the petition number E090 of 2022, which now referred this matter to the IEBC DRC. So the question is, after the matter was referred to the IEBC DRC, did the applicant make any effort to apply to be enjoined in IEBC DRC number 127/2022, where this matter emanated? That's the first question. Because the appeal before you, my lady, is not an appeal after the judgment of the court in E090. It is an appeal after the decision of the IEBC DRC. Did they make any effort to apply to be enjoined in the IEBC DRC? That's the first question, my lady. The second one, if indeed they were not happy with the decision that the court in E090 of 2022, did they make any effort to appeal that decision? Have they demonstrated that they made an effort to appeal that decision? We have not seen any evidence to that effect. And the last issue, my lady, so that I sit down, there were more than 10 petitioners in consolidated petition number E090 of 2022. If we allow the applicant to be enjoined in this matter, does it mean that all the other petitioners have a new way of applying to be enjoined in this matter? My ladies and my lords, in the morning, you noted that this matter is of utmost urgency. Nobody should be allowed to delay the hearing and termination of this matter. Therefore, my lady, we submit that that application be disallowed, and may we proceed to the hearing of the remaining. Thank you, my ladies and my lords, and I will be here to present further decision of the court. Thank you.
Yes, my lady. First, we need to say that the application is opposed by the petitioner, and we have filed and served ground of opposition. And another thing, you can look at the funds that is in service. Two of the ground of opposition and seek to amend the same to read Rule 7 and not 6. But I think everything was being done in a hurry, in the interest of time. Rule 7 of the Sonko rules. You see that I have read it as a minute when I told you. I think you wanted to distract me. My Lord and my Lady, this particular application, if allowed, first, would open a can of worms. Anybody would emanate from any corner wishing to change if the principles that my learned friends endeavors this court to apply what we legitimate. My ladies and my lords, we have two authorities that we have shared and which we rely on, one of which has been referred to by my very learned friend, Mr. Dekwa. That is Supreme Court petition number 12, that is P016 of 2020, the AG versus Devin D and the others. And there's also the High Court's Civil Suit number 115 of 2019. That is John Harold Wong versus Simon Haysom and others, and the AG and others. My lords and my lady, I associate myself with submissions by advocates for the four respondents fully, and proceed to add that jurisprudence on joinder of parties has already been developed. And parties need not loiter trying to be enjoined. And for any party to be joined, they must fall within the principles laid down as laid down in the authentic case. And also the David D case that we have cited. A casual look at the application before courts would show that the same does not fit within circumstances that are laid out by the Supreme Court and the Mukunga rules, Rule 6 and Rule 7. Looking at that application by itself, my ladies and my lords, no identifiable stake can be identified. None, other than having been in another matter. Looking at, for example, paragraph 10 of the supporting affidavit, the same refers to a copy of petition filed in Mombasa. None have been annexed. We've not seen that annexed. There's nothing identifiable specifically relating to the applicants that brings brings them into contact with the petitioner or petitioner's case that they are Kenyans with their rights under the Constitution. And that's why I'm saying, my lady, if allowed, that would open a can of worms. Any competitor or any person, my lady, paragraph 37, of the High Court case, that is the John Harold Moore case, which was decided by your brother, Justice Chichembwe, and which has made reference to the Murotet case. Sets forth conditions that must be met. And one of the conditions is that a party must, in his application, set out the case and all submission he intends to make before the court, and demonstrate the relevance of those submissions. He should also demonstrate that these submissions are not merely a replication of what other parties will be making before the court. My ladies and my lord, if the proposed interested party was given an opportunity to join into these proceedings, he would be making the argument that everybody would be making, the subsidiary parties will be making. They will not be adding any value, because they have nothing identifiable by themselves. And my ladies and my lord, the only party that can come in yes, I'm reminded that we'll be making arguments more so like IEBC groups, just to buttress their case. And my ladies and my lord, the only party that would come in public interest and through an application is the Arrendero under Article 156. The Arrendero may come under Article 156 in the manner that my learned friends, clients, and ever comes. And this application, as tailored, is meant to have a private citizen usurp the role of the Attorney General. My lady, that particular application has not shown what prejudice that they would suffer. In the case of non-joiner in these proceedings, to the satisfaction of the court, and the rule is, as in the Murotet case, that it must not be clearly outlined, it must also be outlined and not something remote. My ladies and my lord, I would ask my learned friend when he comes back to show direct nexus. Something not remote to warrant his being joined. They've not even stated whether or not there are voters from Mombasa County, for example, for them to have a stake as voters. This court is not seized of the matter that has been referred to, that is petition number 230 at all. And my lady, for this court to be invited to deal with matters relating to those petitions that were before Justice Majanja-led bench, this court would be actually being asked to sit on appeal of a decision made by a concurrent court, contrary to Article 164. My lady, as properly stated by my learned friend, any citizen, and my lady, incidentally, all of us were actually in those matters. During the pendency of those particular petitions, orders restraining the petitioner from presenting his papers were lifted, even as that matter was pending. And on the following day, he proceeded to present his papers. If the proposed interested parties were really enthusiastic and tenacious about opposing the petitioner's candidature, then they would have proceeded under Regulation 42 to the CRO and made their objection for the CRO to consider. And joined the DRC proceedings. Which they never did. They've stated their interest in that they endeavor to come in, and their interest is that the petitioner was impeached under Article 75 of the Constitution, and therefore the question whether or not you would benefit from Article 193.3 would be in question. Now, are they coming as experts in constitutional law to render or to advise, to give an advisory to the court? And that is what actually would lay them square. That is the only thing that they would come in here to add, which is not the case. They would come and argue. They would, in the same way we are arguing. And it moves forward. What orders are they likely to get or benefit? My lady, allowing this particular application would be dragging this court into matters that this one the court is not seized of, thus violating the principles of equality of arms and full disclosure of material matters. Firstly, my learned friends, that is the applicants, are guilty of material non-disclosure, non-disclosure of material facts. They ought to have brought this court, even those judgments, for the court to appreciate, which they never did. So, my lady, I would urge this court to be guided by the principles in those cases that we've cited, which we've supplied to courts, and to deny and disallow the proposed interested party the right to join these proceedings, and to issue directions that will obstruct this matter, rather than have a busybody who comes in just to waste time. I would not stop until I submit that the proposed applicants are busybodies with no stake at all, with no interest that would warrant being joined. All these, the members of the public that are here are actually participating. They are listening to what is happening in court. They are actually, I would say that his client is actually welcome to listen if he's interested, but not to raise anything. That's all, my name.
I take 3 minutes break. My lady, may I say that I support and adopt every submission as usual, name and my land friend is Mr. Udinga. The Honorable Court, a petition before you is a serious application. Raises serious issues before us and continues to suffer. There is absolutely, with tremendous respect, no merit whatsoever in submissions made by my learned and good friend, Mr. Woodward. As my learned friend, Mr. Nyamu has said, this application comes from Ireland and is a busy body. And there will be many coming up in the matter of Sonko for personal gain elsewhere. And I'm inviting you with respect. You send a clear message and a clear signal to them that this is a serious high court and you do not entertain such applications at all. My lady, as I said to you earlier, you have tremendous discretion. Don't allow anybody to say anything here. If Hamilma is with respect saying things that have no merit, tell him to sit down. Don't allow him to talk at all. We came here to hear a petition. We are ending up, we're going to adjourn without having heard anything at all. Because of frivolous applications like the one that has come from Sonko. I have finished my list. With that review, I sit down. Thank you.
Lady, may I conclude by saying 1 minute. My name is Odiambo. I am present for the petitioner. Number one, I wish to associate myself fully with the sentiments and submissions by my learned colleagues, particularly the petitioner and the ones representing Wiper Party. My lady, I will open this quote by reading an authority which comes from international. Let me quote, it's just one paragraph. International Center for Policy and Conflict versus Attorney General and others. This civil case number 226 of 2013, where Justice Odunga ruled as follows. Courts are members of justice and the last frontier of the rule of law, and must therefore remain steadfast in defending the letter and the spirit of the Constitution, no matter what other people may feel. To do otherwise will be to nurture the tumor of impunity and lawlessness. My lady, why I'm saying this? Pardon? It's in paragraph number 45. Yeah, it is quoted by authority in Judicial Review Miscellaneous Application number 78 of 2017. Republic versus Evans Terror Foundation. My lady, why am I quoting this authority? It is straight law that this honorable court, which has been clocked by the jurisdiction under Article 165, has original and limited jurisdiction. However, the jurisdiction of this honorable court goes upwards and not downwards. My ladies, the moment this court is going to be compelled to allow the applicants to participate in this matter whose substrum is a subject of DRC, Dispute Resolution Committee, an appellate jurisdiction. And that is the business why we are here. My lady, even going by on the face of it, if you look at the application, Melody will have two annexures. We'll have a proof that the applicants are voters or whether they are Kenyan citizens. We do not have an extra of their identity copy. Therefore, for this honorable court, or even the parties here, to determine whether we are dealing with actual natural human beings, a juristic person,